Do you care to say a few words about how you think today in particular, but the case in general?
I believe that the case, in terms of the way the evidence went very well. I think that what the Department of Correction acknowledged from their own witnesses was that you're not getting treatment until you get cirrhosis for hepatitis C. Came from there. It was the biggest gift today. Was that my mouth dropped open, and the law is clear that although prison system has discretion, a certain amount of discretion in healthcare, you can't wait until someone has a serious or life-threatening disease before you can commence treatment. And to that extent, I think the evidence went well. What happens from here on in, who knows? The judge, I think, seemed attuned to the issue. There's bad law in this area, but I think even under the bad law, we should win. And I'm the eternal. When it comes to the courts, I'm the eternal pessimist, and I almost feel like when I want to be optimistic, something bad's going to happen. But the way it came in, we could have done. We could always have done better, as Rachel said. But I think that we, with our limited resources and against the resources of the state, and with being able to look at Mumia while I'm examining, with him sitting there, was fabulous. And thank you. And the supporters, were great.
There it came out today that there was some discrepancies between the affidavit signed by Dr. Neal and what was submitted to you. Dr. Noel, would you care to comment on that?
That took me by surprise, as you could see the way I was fumbling. I had to run over to Brett and say, did I take the wrong? Then I saw, no, this came out of the court file. And apparently, it was a technical thing. He made, in the affidavit that we have, he made a claim that was totally scientifically false. And when I showed him the affidavit, he knew that paragraph, and he said, I gotta sign that, because I know that that's false. But they filed it with the false paragraph in it.
Not only did they file it, but I was relying on my briefcases. Here's their brief. They relied on the level of the viral load, so how how much of the virus is present in the blood as an indicator of disease progression, and it is not an indicator of disease progression. And they were trying to argue that because he had low viral load, he doesn't need treatment. Inferring that he might not develop a high enough viral load for consideration of treatment for a long time, eternity, essentially. And not only was that paragraph left in the declaration, but they made legal argument on it, and that was adopted by the magistrate. She adopted everything they argued in her recommendation to the full court. And DOC counsel said to the court it was a clerical error to try to say that it was inconsequential, but it was consequential enough for her to try to argue to Judge Mariani that you shouldn't issue the injunction, part based on this evidence, and he was not pleased.
No, it was at best gross negligence for them, or deliberate misrepresentation to the court on the other end. And Dr. Noel, for his part, wasn't going to happen.
It's his reputation.
But then he also admitted that he stated the infectious disease specialist had ruled out hepatitis C as a cause. He determined that hepatitis C was not the cause of Mumia's skin condition, and he acknowledged under excellent cross-examination that the infectious disease specialist actually made no such determination, and that his statement in the declaration, which they also relied upon to argue against the injunction, was untrue.
There also seemed to be a discrepancy between his reading of discharge papers that he claimed to have and the ones that were introduced as evidence.
There was something very minor,
Yeah.
but it was, and they actually, it's not for this, it doesn't need explanation. That was something minor, but it was, but what the important point was, he testified on direct that they take the recommendations of specialists. And when he was released from Geisinger, it said hepatitis C follow-up, and they never followed up.
Yeah, they
And
never saw
but
that.
all along, they said they take the recommendations of specialists.
We know you're exhausted, but two quick and final questions. So it came out that in this regard, this is in relationship to the interim protocols that were introduced yesterday by Attorney Neal, and to which
They were disclosed.
they were
produced
disclosed.
yesterday
They were
because
disclosed,
we
to which you were asked to
discerned there.
sign a confidentiality agreement that you would reveal. Would you care to comment on that?
Sure. Judge Mariani wanted us to work this out amongst ourselves, although he made it clear that he saw no reason why these should not be entered into evidence the way that any other exhibit would be, and he wouldn't enter them under seal. The DOC, knowing that if they were entered into evidence, they would be a public record, approached us again this morning, not only attempting to get us to enter into a confidentiality agreement, which would have been enforceable in court. They didn't show us any text, but that's what they described. They also surrounded us and attempted to pressure us into not entering the protocol. I'm not going to call it the interim protocol. This interim thing is a fantasy. This is their HepC protocol. They, until the court tells them otherwise, right? I mean, that's the only thing that is interim to is judicial opinion, but I digress. They wanted us to not enter this into evidence as an exhibit, saying that they were being reasonable by allowing us to use their protocol, which they are defending, to question their head of medical services. So we agreed to none of that. It was entered into the record, and then at the end, the judge asked if that issue still needed to be resolved, and they said that if it was resolved during the course of the proceedings. I assumed that was because it was entered into evidence, but one of the DOC attorneys said that they communicated with the Right to Know officer in the DOC, and the Right to Know people told him that this is getting released. There's no grounds for keeping it privileged. So we can go home and scan that tonight and share it to anybody that has it.
And Dr. Noel actually testified to that in his cross.
And the protocol, as it applies to everyone else in Pennsylvania, basically, and if you listen to him testify at the beginning, he was explaining it kind of, we don't want to create the impression, because all the protocol talks about is that people with cirrhosis or decompensated cirrhosis are the only ones that they're going to treat. So you already have to have almost fatal liver disease.
Through the society.
It's even a little more vague than that, because it has these priorities, right? But their testimony made it clear not that they would only treat those who are highest priority, but they would only consider those who are highest priority for treatment. Their policy is to not treat anybody with hepatitis C. Their own evidence proves that. 5 people out of 6,000, and even under the old treatment, when they suspended the policy in 2013, they had 22. That is shocking. It's totally outrageous. It's absolutely illegal.
It's like 10,000 people in the prisons now
He
that
said
have
7,000.
The difference between who's HepC positive and who's has a chronic infection, but he also said the 7,000 wasn't, she said it was an estimate, but it's still pretty high.
He also stated that they based their interim protocol on a combination of what the VA, the Bureau of Prisons, and Medicaid rather uses. My understanding from what I've read is that those 3 entities treat roughly 2.7% or 2.4%, but over 2% of the cases that come before them. To do the math on what he's saying, you're talking about less than a tenth of a percent.
Well, I mean, let's be clear, the Federal Bureau of Prisons has one thing in their policy that I agree with, and that is that it recognizes the American Association for the Study of Liver Disease and the Infectious Disease Society of America as the standard-setting organizations. But they do have a prioritization of treatment, and I'm not aware of any knowledge that they're treating people on a widespread level, and I would not hold up their policies and practices as evidence of something that's constitutional. You know, we need to find other lawyers to go after them on a class action.
At least in their protocol, they state, we're going to aspire to these other guidelines. And they're not great because they're not treating everybody, but at least it's written down that we're going to aspire to the goal of treat everyone.
And kind of one final
Pennsylvania,
question,
they're better.
for the sake of not holding you a lot longer. So there are 21 days given for the transcripts to be produced and then 21 days for the brief. Is there an estimate of when we could expect to be back in court on this brief?
The 13th.
You may not be back.
Or may not be.
You can issue a written decision.
He will issue a written decision. There's other ways that the case can play out once the written decision comes, from who the injunction goes for, what appellate rights there are. A preliminary injunction is not the end of the case, so there's lots of variables. They could just give him the treatment, right? But they're not going to do that because they have they're kind of really,
Springs eternal.
I
I
don't,
said there was a 1% chance of them giving him the treatment.
I think it's diminished. I think they've been too humiliated.